Hi, my name is Easton Lewis, and today I'll be continuing with Chapter 12, which is the Product of Service Liability Law. At the beginning of this chapter, it describes theories of recovery in product liability cases. Negligence is described, breach of warranty is described, and strict product liability describes. Negligence is the plaintiff must prove that the defendant manufacturer owned a duty of care, the defendant breached the duty of care, the breach of duty caused the plaintiff's injury, or the plaintiff suffered actual compensatable injury. It also goes with a privity limitation, and this is that the plaintiff must have purchased the good directly from the defendant who manufactured it in order for the defendant to owe a duty to the plaintiff. Next, the negligent failure to warn is described, and that's when a plaintiff must demonstrate that the defendant knew or should have known that, in the absence of a warning, product would be dangerous for its ordinary use or any reasonable foreseeing use. It describes with the toxic or allergic reactions for cosmetic or over-the-counter drugs, no duty to warn unless the plaintiff proves that the product contained an ingredient to which an appreciable number of people would have advertised reaction, the defendant knew or should have known, and the exercise of ordinary care that if this was so, and then that the plaintiff's reaction was due to his or her memberships in the abnormal group. Continuing with negligence, the negligent design is described, and this is when the plaintiff must prove that the product design is inherently dangerous, contains insignificant safety devices, and consists of materials that are not up to the industry standards. Negligence per se, that the plaintiff must establish that the breach of the statutory duty caused injury. Next, the chapter describes the strict liability in contract for breach of warranty. And the warranty is a guarantee or binding promise that the goods meet certain standards or performance. The express warranty is a warranty that is clearly stated by the seller or manufacturer. And lastly, the implied warranty is a warranty that automatically arises out of transaction, usually off of merchantability or the fitness of a particular purpose. The implied warranty of merchantability is a warranty stating that the product is reasonably fit for ordinary use. To meet merchantability standards, goods must pass without objection in the trade under the contract description, be fair quantity within the description, be fit for the purpose for which they are used, and run with the variations permitted by agreement of even kind, quality, and quantity within each unit and among all units involved. Continuing with the implied warranty of merchantability, states that must be adequately contained, packaged, and labeled as the agreements may require, conform to affirmations or promises made on the label or the container, and the limitations for this is it can be used only by one person who is regulatory engaged in the sale of that type of good, and the seller must avoid liability by expressly disclaiming liability or limiting liability. The chapter continues with implied warranty of fitness for a particular purpose or express warranty. And this states that implied warranty or fitness for a particular purpose arises when the seller tells the consumer a good is a fit for a specific use. If the consumer is injured while attempting to use the good for the mentioned purpose, a lawsuit can be filed against the seller. And the express warranty is created by a seller by describing the goods, making a factual affirmation regarding the goods, and providing a model or sample for the goods. Next, the chapter introduces defense to breach of warranty actions. And this is when a purchaser's failure to notify the seller within a reasonable time about the breach of warranty. Courts avoid this requirement by holding that a long delay is reasonable under certain circumstances. The requirement does not apply to personal injury situations, and the requirement is incapable between parties who have not dealt with each other. The disclaimer is the disavowal of liability for breach of warranty by the manufacturer or seller of the good in advance of the sale or of the good. The disclaimer may state that no warranties are made, manufacturer warrants only against certain defects, and liability is limited to repair, replacement, or return of the product price. Next is the strict liability and tort. And this is when one who sells a defective product that is unreasonably dangerous to the user or consumer of his or his family, subject to liability for physical harm thereby caused to ultimate user or consumer, or to his property if the seller is engaged in business of selling such a product, and it is expected to and does reach the users without sustainable change in the condition in which it was sold in. And then next is continuing with the strict liability and tort. And this is the rules applies even if the seller has exercised all possible care in the preparation and sale of the product. The user has not entered in any contractual relation with the seller, and the strict liability action requires that the plaintiff to prove that product was defective when sold, defective condition rendered the products unreasonably dangerous, and the product was caused by the plaintiff's injury. Proof of the defect is provided by the experts who testify as the type of flaw that could have caused the accident, the evidence of the circumstances surrounding the accident that led to the injury to interfere that is caused by a defect in the product, and the consumer expectations test and risk utility test. And this is used to determine if a product's defectiveness constitute as a reasonably dangerous. Next, the chapter describes the defenses to a strict product liability action, and it introduces the product misuse, assumption of the risk, and the state-of-the-art defense and subject to controversies. It also introduces the market share liability, and the market share theory is damages are apportioned amongst all manufacturers of the products based on their market share the time that the plaintiff's cause of action arose. The factors require that all defendants are tortfeasors and elegantly harmful products are identical and share the same defect quantities. Continuing with the market share liability, is the plaintiff is unable to identify which defendant caused his or her injury, and the manufacturers of all the defendant's products in the relevant area and time are named as defendants. And then next is the service liability, which occurs when someone or someone's property is harmed because of an inadequately performed service. Malpractice suits is also discussed, which is service liability suits brought against professionals based on a theory, negligence, breach of contract, or fraud. And then lastly, the accounts liability is introduced in the chapter. And as the plaintiff is required to prove the duty, breach of duty, causation, damages, and the standard used in determining reasonable care. Alternative rules to determine accounts liability to third parties is introduced as the alter maris doctrine, which accountants are liable only to those in a private or contract relationship with the accountant. Section 552 of the restatement, second of torts, which is the accountants are liable to a limited class of intended users of the information, and the reasonable foreseeable rule, which extends the liability to third parties adversely affected by the performance of other professionals. And then last in the chapter is the global dimensions of the product liability law. And this occurs when an imported product that causes injury to the consumer in the U.S. is sold. Plaintiffs sue the retailer or wholesaler who sold them the product rather than the manufacturer who's located in another country. The collectability of the judgment is when the plaintiff can ask the courts in the country where the manufacturer is located to execute a judgment against the defendant's assets there. And in the case of the U.S. products sold abroad, the U.S. manufacturers may be brought before the foreign courts, and the foreign importers of the good manufacturers in the U.S. are willing to join the U.S. manufacturers in lawsuits, so as to distribute the cost of judgment. And that's all I have for chapter 12. This chapter was interesting to me, just learning about the theories of recovery in product liability cases and learning the details about them and how they're used in the court of law. So, thanks.